Good evening, good morning. Like, share, subscribe, do something with it. Not legal advice. Nice to have you here. Tonight, I kind of wanted to talk about decision of judge versus jury. So I'm going to let you be the judge on what you would choose. Um, our joke for tonight, I tried to sue my airline for losing my luggage. I lost my case. Again, thank you to Little Bruce T. Thank you again for that wonderful joke. So, when I first started practicing in 1894, it took over 5 years to get to trial in Los Angeles. That encouraged people to find other routes because it took a long time to get any satisfaction. If you were a plaintiff, in other words, if you were the person who was harmed, and it took you 5 years to get to trial, it was very frustrating. Really wasn't fair, and it was a problem. So that encouraged people to find alternative ways of resolving disputes. It also ultimately caused the LA system to speed up. So now it takes generally less than 24 months to get to trial. So that's a substantial change. So we previously discussed arbitration. There's a prior video I sent out a couple of weeks ago, or 2 or 3 weeks ago. I think the name of the video is FINRA arbitration. It's yucky, something like that. So what if we're not talking? And FINRA arbitration obviously is relevant because it could be appropriate to all uh, claims with brokers. Could be, although we're testing that in the MMTLP matter. But what happens if you have a choice between a judge and a jury? Some matters you don't have a choice, like declaratory relief or requesting an injunction or something along those lines. You wouldn't be entitled to a jury, and that would be strictly for a judge. But in most civil and non criminal, so civil or non criminal cases, there's an option of a judge or a jury. So, in other words, you get a chance to pick it during as the case proceeds. There might be certain things you have to do to preserve that right, but you have a right to do that. And there's a difference between a judge and jury and arbitration, as we discussed. It's generally two things. One is the appealability. There's generally very little in arbitration, and often the size of the awards. So the size of arbitration awards are often substantially less than the size of awards in front of a judge or jury. So as a result, there's much more downside risk in court to defendants, but courts are not always available, or they're costly or slow. And I know in the MMTLP matter, so we're going to have a chance to, hopefully, a chance to decide between a judge or jury, and hopefully stay away from arbitration unless we have to, and then we'll deal with it that way too. We'll deal with it. We'll deal with it as it comes up. I have no concerns, honestly, about that. And that's not what this video is about. So in either way, up through the time that a jury is selected, although the documentation is different, so in a, a jury trial, there's a lot more documentation that you have to submit to the court because there's statements that you're going to read to the jury that have to be agreed upon. There's jury instructions that have to be agreed upon. So those kind of things. And that creates a lot more paper and a lot more time. So it's more voluminous, more timely, and more expensive in that way. Um, but up through the time when the jury instructions are read and the jury is picked, the role of the judge is basically the same in a case where it is decided by a jury or decided by a judge. He or she manages the case and rules on motions and other hearings, um, conducts status conferences, sets trial dates, and conducts trials and possibly mandatory settlement conferences. Those are settlement conferences that are sometimes conducted by judges on other judges' cases. Some judges have busier calendars than others. I mentioned LA above. The downtown LA Superior Court, which is the Stanley Mosque Superior Court, happens to be the busiest courthouse in all of the world. so it's slow. So in that kind of facility, the judge's role changes somewhat. They're a manager. They're really a manager of cases, and they're in part like an insurance adjuster managing their calendar. Uh, so that's kind of what in large part what a judge would do, outside of whether it's a jury trial or a judge trial. Um, so often judges set their calendars, and sometimes when they set the calendars and set trials, they may set multiple trials on the same date. And so it may be today, and they're setting 5 trials 6 months from now. But it's amazing, about 95% or more of cases settle, no matter how far apart parties are to start. So it seems like, in large part, those calendar conflicts work out. And if they don't work out exactly, then you're just kind of waiting in a queue. But it kind of moves relatively efficiently. Relatively. Of course, it makes a difference whether you have a jury trial or a court trial. If it's a court trial, then the judge kind of tries to fit you in like open spots. And when it's a jury trial, it's got to be a straight on through. So there's a less flexibility in doing that. So if the parties elect to hold a court trial, those trials are generally shorter, less cost. The judge will generally be pretty active in the trial, or they can be active in the trial. They often ask questions and direct inquiry and direct the attorneys to inquire about certain areas. They're often less restrictive when it comes to excluding evidence because ultimately they're going to consider the evidence, and if they don't think the evidence is of particular value, even if they let it in, they're just not going to give it much weight. That's kind of what they say also during trials. The judge may ask witnesses questions, and when the case is finished, and this is kind of where it differs a little bit from a jury trial. So case is over, judge has ruled on the case, or at least taken the case under submission, let's say. Then he has about 90 to 120 days, subject to extension, to issue a tentative decision. Then the parties have an opportunity to object to the tentative decision, and eventually a final decision is issued. But that final decision might be 6 months after the completion of the trial. Could be subject to appeal, but especially where you have two unpopular parties, for example, where a bank sues an insurance company, for example, using a judge often might be the best choice because the jury may not be particularly sympathetic or interested in those kind of parties. So let's now move on to a jury trial, and let me start, and I'm going to put kind of something in an order for you. So in a jury trial, the judge usually is less involved when it comes to with regard to him actually putting on evidence, asks fewer questions. The judge usually closely monitors what is said in court. He or she is more careful about what is said in court to not influence the juries. In a jury trial, a judge would be much more restrictive as to the admission of evidence to the jury. Now, the general order of trial, and I'm going to get back to the jury in a second, but the general order of a trial, just so we kind of have an understanding here. First would start off, both sides would give opening statements, and those are going to be timed. So there'll be some agreement as to how much time each party has to give an opening statement. Opening statements don't have to be given, they can be reserved. So defendant, for example, could decide to wait to give their opening statement or could waive it, although that wouldn't be very smart. But they certainly could wait to give it when they start their case, for example. And it happens. I've done that before myself in particular times. So after the opening statements, and by the way, there's breaks. So the jury comes in, they'll stay in, there's breaks during the day. And so now we're started the trial. Maybe, what often happens, opening statement, then maybe other opening statement, then a break. And if we're not like in a lunch, if we're still in court time and court time is limited, it might be only literally 5 hours a day in reality. So it's limited. So it's very precious. So after the opening statements, The plaintiff would put on its case. Defendant would cross-examine plaintiff's witnesses. Defendant would then put on its defenses and witnesses. Plaintiff would then cross-examine those witnesses. There might be expert witnesses that both sides put on. Then there might be rebuttal witnesses, which is basically witnesses you bring in to kind of clean up on areas that have been covered. There might be cross-examination of those rebuttal witnesses. Then we have closing argument by the plaintiff, closing argument by defendant, and then we have a final reply argument by the plaintiff. Since plaintiff has the burden of proof, and just by a preponderance in a civil case, it'll be by a preponderance of the evidence, which means they just have to prove more than 50% of the evidence, but the burden is on them, so they get the last argument in the order of events. So now we'll go back to the jury trial. So we've done that, final arguments. Then what happens in a jury case, and unlike a court case, a case where the judge is deciding, then the judge would read the appropriate law to the jury in the form of jury instructions. And again, those jury instructions would have been previously submitted by both sides. They would have been litigated before the court, and there would have been some agreement as to a set list of jury instructions. And that's the law, the jury instructions. That they would be provided to the jury. The jury then would go deliberate, review the evidence, and issue a ruling. So the ruling would be issued at that time. That becomes then the judgment. So in a jury case, because you have to find the time for the block of time for it, it might take longer to get to that point, but when you get there, the results are going to be much faster. And oftentimes the verdicts are much larger, but in general, jury verdicts are much more unpredictable. So those are kind of the various issues that come up. Plaintiffs with sympathetic victims, for example, always will choose a jury because potential awards will be substantially higher. So a trial, when you have a judge, is generally faster, but lower verdicts and finalizing a decision can be slow. A jury is slower to get to the end, faster once you get there, good for sympathetic plaintiffs, and the judges are less active. But in general, both will produce bigger awards than arbitration, but you'll probably get to an award in arbitration generally faster. Anyway, hope that helps. Judges versus juries. Have a great night. Be well. Take care.